If everybody's ready, I think we've got a quorum. We'll go ahead and call the meeting to order. Preacher Mills, could I ask you to open us up with a word of prayer? Would you? What do you need to do?
For your love for us, we ask, Father, for divine wisdom that we can make decisions that will be pleasing to you. In Jesus' name, amen.
Okay, we'll start out. Mr. Chokas, House Bill 488. Yeah, I think that'd be best. Easiest with the microphone, everybody can hear you.
For your consideration today, House Bill 488. House Bill 488 was brought to my attention, or the request for this legislation was brought to my attention by local magistrate court judges. There has been some confusion in who is the holder in due course and what some magistrate court judges could do and what they could not do. I've got a letter of support from the Department of Law, and I'll cut to the chase on that. I didn't pass out that letter. I'm sorry, I came unprepared, but I gave Mr. Chairman a copy of the letter from the Department of Law. And on the last page it says, while current law may already permit such prosecution, your proposal would certainly make it clear through codification. And it deals with, as I said, who could prosecute an instrument of deposit account fraud under current legislation. It also would allow for the magistrate court judges to collect warrant fees and certified mail fees. These are in addition to the fees that are currently being charged to the merchants that receive the bad check. And I'll be happy to answer any questions.
Okay, now, as you might have noticed, this bill, either of these bills did not go through the subcommittee process, so we'll take as much time as you need reasonably to let's, vet the bill. So any question you've got, let's go through them, because we're functioning as a subcommittee ourselves and committee. Chairman Earhart, did you have a? Okay, it's on, I believe, isn't it? Is it? It's got a green light.
Are you 89? 88. Oh, sorry.
There it is. Thank you. Thanks, Mr. Chairman. Representative Chokas, just a question. Let me get maybe you can give me an example. I want to make sure the service charges, and I don't have the code section in front of me, so I'm not sure, but it seems to me this also refers to a basic NSF charge as well. Are you saying those are already at $30? Are you saying that the banks and the attorneys and the courts can add to those? You know how those sometimes begin to roll over if there's a mistaken deposit, if the revenue department forgets to deposit your fees or takes back your tax return. At that point, then, instead of just the individual $30 charges, you're now going to add on those individuals. I understand a deposit fraud or a bad, but these present considerations, those could run into hundreds and hundreds of dollars each.
Mr. Chairman, thank you. I'll be happy to answer that question. When a merchant receives a check, a bad check, deposit account fraud, first thing that happens is the merchant is charged a fee from the bank for accepting the bad check.
I'm familiar with that.
Okay. And then he turns it over to the magistrate court. That's where there was some confusion as to whether he has to do it or whether the agency collecting on behalf of the merchant can do it. And there is a service charge involved with the collection of that. That's where the $30 comes in. If they have to file a warrant, there is an additional warrant fee that would not be covered under that service fee. And then there's also postage, certified mail postage or registered mail postage that is required by law and would not be recouped. So these are where these fees arrive. These are fees that are going to be charged the merchant whether they're able to collect on the check or not.
Okay, let me make sure I understand if I can follow up, Mr. Chairman. All right, I understand the merchant side of the equation. I'm sympathetic to that. I want to make sure that this is specific enough that we don't go into the bank side of the equation with an increase in what you can go over that $30 mark.
I understand.
And are you comfortable that line 14, and accept that the holder of the instrument refers specifically and only to the merchant and not the bank in that sense, or financial institution in that sense? I've got a little bit of angst if the $30 NSF charge that comes from that side of the equation. I'm sympathetic with what you want to do. I want to
yes, sir.
Help me to get a comfort level in between.
The comfort level is in line 20 and 21, such party's agent. That's where the comfort level, that describes who actually collects on the check. So, and I'll go step by step. If a merchant receives a check for, let's say, $50, the first thing that's going to happen is going to come back from the bank, and the $50 will be debited from the merchant's account, and then a service fee from the bank will be debited from the merchant's account for collecting, for running a check through the bank. Without the merchant even knowing that it's bad. Okay, the merchant can do one of two things. He can either turn it over for collection at that time, or he can run it through the bank a second time. If he runs it through the bank a second time, there's an additional fee. If he decides to give it to a collection agency that collects checks on behalf of merchants, they are going to charge the merchant a fee for collecting that check. If they are unable to collect the check and they have to turn it over to the magistrate court to sign a warrant, there is a warrant fee that was set when we did the fees last year under Chairman Smith's thing that is codified, and that fee will be charged to the merchant whether the check is collected upon or not. Once the warrant is done, there is a fee that is paid up front. So all of a sudden the merchant is out his money, he's out the warrant fee, he's out certified mail fees, which are required by law before he can even begin to collect on it, assuming he can collect on it. So what's happening is our merchants see these costs building up, and so they decide that it's not worth spending another $20 or $25 to collect on a check, and so they don't collect on these checks, or they don't turn them over, and so you have people writing checks for what they know the cost is going to be to the merchant, and the merchant deciding that I'd rather eat that cost than try to collect on it.
Okay, thank you. Good explanation. It makes a case for the merchant getting together with the bank and getting a check validation service.
Absolutely. Absolutely.
Thank you, Mr. Chairman.
Yes. Yes, sir. Reverend Chokers, one question. Does House Bill 488 speak exclusively to check fraud, as there are several different types of deposit account fraud? Is it speaking exclusively to check fraud?
Deposit account fraud, yes, sir. Writing a bad check.
Okay. Thank you.
Thank you.
Does anybody else have a question for the author? Representative Mills, I believe.
Chokus,
Yes.
Was there any discussion about in situations where there is let's say a $5 check, and it is a bad check, and we already know, you shouldn't write a bad check no matter what, but sometimes people don't balance their accounts, and so they're taking a pretty big hit when they're paying the what happens in those situations as you just described? When that's turned over to a collection agency, do they go after the $5 checks, or they just let them go?
It depends on the merchant. If the merchant turns it over for collection, they'll go after them. If the merchant decides not to, they won't.
Was there any discussion given in that regards about, I mean, you kind of don't mind it when somebody intentionally writes you a bad check, but when somebody messes up and writes you a $5 bad check, I wouldn't want them to have to wind up paying a court cost fee, et cetera, just because of an accounting error. And how does this bill address that?
Thank you for the question. The warrant fee does not come into effect until they do not make good on the check. Under current law, the merchant is entitled to the amount of the check, a service fee. Now, if the person that writes the bad check unintentionally, he's still going to have to pay the service fee and the amount of the check. Okay. If it's an innocent mistake, it's not going to be necessary for them to file a warrant. So right now he's going to, and it's already in code, he's already going to have to pay the collection fee and the face value of the check. What happens is, if it's not an innocent mistake, we're adding the warrant fee and the certified mail fee to the expenses that they need to pay to make that check good. And this is if they decide not to, if they have to sign a warrant for their arrest. If someone writes a $5 check and it's already in code that there's a $30 or 5% of the face amount, and if you'll see under section line 10 and line 11 in section 1, that's already in code. They're going to have to pay that. It's the ones that are writing the checks for $20 and $25, knowing that the merchant may or may not try to collect on it.
Right. If I may, Mr. Chairman, I understand. I'm in the mini storage warehouse business. I understand the process on bad checks, believe me. I guess right now, when the merchant takes that before the judge, can the judge not make them pay those fees anyway under current law?
I don't think that's possible. That's why we're putting it in the code section. I think that they have to pay the service fee, that collection $30 service fee. And most of that, as you already know, goes to the collection agency, not unless you collect on them yourself.
Mm-hmm. Well, I'm very sympathetic as a business person on collecting the monies that are, promised and committed to you. I guess my one point of concern is that $5 unintentional. I have people who move away. Naturally, they're moving. They're in storage, and I can't locate them. And so I just want to be fair at the same time. I mean, they should pay me the $5. I understand that. But I don't also want to drop a sledgehammer on them.
Well, my question to you is this. If someone writes you a bad check, what do you do to collect on it?
If it's not a large enough amount, honestly, I just write it off and don't even fool with it. I think that's what most merchants do, but that's what I do in my business.
And this law would not change that. If a merchant decided not to collect on it, it's possible.
Representative Wells, do you have a question?
Yes, Mr. Chairman. Thank you, sir. Representative Chokers, it's my recollection, and I haven't looked this provision of law up recently, but it's my understanding that in order to get the bad check fees and all the other expenses that a merchant incurs, they're required to write a letter. It's a form letter set up in the statute. Send it to them, and they had 10 days to pay the stuff, and then that you couldn't bring an action against the issuer of the insufficient fund check.
That's correct.
And that's still current law.
Would not change any of that.
And that law still stands. This doesn't adversely impact that process.
No, sir, not one bit.
And, Mr. Chairman, briefly, isn't it further true that if that letter is not sent to the person who issued that insufficient fund check, that the expenses and bad check fee may not be recoverable?
That's correct.
Thank you, sir.
Chairman Burns, you have a question? No? He waits. Anybody else? Yeah, Chairman Hill has a question. Okay. Well, that would be that time.
Mr. Chairman, I'd like to make a motion to pass our recommendation on House Bill 488 LC 2170.
We have a motion and we have a second. Is there any further discussion? Those in favor of the passage of House Bill 488 will signify by saying aye. Aye. Any opposed, same sign. Motion carries. Congratulations, Mr. Choate.
Thank you, Mr. Chairman, members of the committee.
Okay. Mr. Weldon, 465. Okay. All right. No. Does everybody have a copy? Everybody's got their copy? 465. Proceed, sir.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I'm presenting to you today House Bill 465. This is LC 294754S. This is a bill that provides that in the event a corporation is going to execute a document that conveys an interest in real property, for example, the release of a security deed or an agreement, security agreement, that they're not required to have the corporate seal. If you look down on line 23, if they're transferring a deed to secured debt, mortgage, or other security, well, up in line 17 in subparagraph A, notwithstanding the lack of a corporate seal, and that just takes out the corporate seal requirement. Subparagraph B just says that if they're transferring a deed or secured debt, and that's the assignments. And the problem, the question, the reason we're having that this is necessary and why this will help bankers, it'll help bankers, it'll help everybody in the public, it'll help title insurance carriers, it'll help closing attorneys, is that this is an incentive for them to have good, clean paperwork where they release or assign these mortgages or security deeds, and they file it with the clerk. They don't have to have the corporate seal, so long as the president, vice president, secretary, or assistant secretary, and it's limited to those officers, execute the conveyance. And it's conclusive evidence once we have the proper person signed on as the release, assignment, or conveyance of a mortgage or security instrument.
So this means next time I close these, I don't have to tear my desk all apart looking for the corporate seal.
Exactly, Mr. Chairman. That's exactly right.
All right. Yeah, that sounds pretty doggone good. I think Chairman Earhart has a question for the author.
Yes, sir.
Thank you, Mr. Chairman. I agree. That seems to make a lot of sense. The one piece I want to ask you about is on line 24. You're changing an officer to, and you're going to be specific about who can sign these pieces of paper. Think about an LLC. That's for the purposes of an officer. That's assumed that's a managing member, that type of thing. If you're going to, many LLCs do not have presidents, secretaries, assistant secretaries. Some of them. Are you going to preclude the managing members of an LLC? I would suggest we look at that. I'm trying to understand why it would be what's wrong with one officer rather than being specific to the vice president and that kind of thing. Just a small concern. I like what you're doing. I'm concerned that may create a problem.
Yes. Mr. Chairman Earhart, I appreciate that question, and I believe that's probably an excellent addition to this. I have with me today John Taylor. He's the he's the leader of the section of the real estate.
I'm the chair of the legislative section.
Chair of the legislative section of the State Bar of Georgia, and we've run this by them, and that's I'd prefer to defer to he's certainly an expert, and I'd ask that he be able to respond to that.
That's good. Thank you, sir.
Thank you. As a caveat, this has not been run through the bar formally yet, but through our process, the 1457A, as it stands, speaks only to corporations. That's typically the kind of entity that seems to be causing the issues, holding the security deeds from whom you need to get a transfer or a release. Your question about authorization for a signatory for an LLC or any other entity is well taken. That's outside the scope of the existing statute.
So that's not in this 1457A?
No.
That's a separate, these are C corps under.
Well, any corporation.
Any
Right.
incorporated.
The statute has historically spoken only to corporations. The statutes are somewhat aged, so they haven't taken into account the LLCs and other types of entities. In A, that has been the general mechanism for the execution and getting comfort with the execution by a corporation. If you had execution by a president or a VP and attest by a secretary or assistant secretary, you were fine. There's been some confusion among practitioners about whether or not you also had to have a corporate seal. You'd have some title examiners that would set up a problem if it didn't have the seal, even though, so the addition in A would put all the examiners at ease. If we have these officers, no corporate seal, we're good. In some circumstances, they may want to appoint someone else. Of course, the problem there is if the document is signed by someone else, they have an internal resolution to provide for it. An examiner has no way to know. That's the reason for the provision that says, yes, you can do that, but the resolution has to be recorded with the document so the examiner knows, yes, this is a properly authorized document. You go down to B. B spoke specifically to, up as of right now, before implementing these revisions, the documents that would release security deeds or mortgages. And rather than speaking of a president, vice president, particular officers, it just simply speaks in terms of one officer of the corporation, very amorphous, or by an individual designated. So you get back to the same question. What we propose to do with this bill is to have it track A, but with the caveat that, and this is to facilitate the transactions that have been all over the news lately, is that with one officer, but it has to be a specified officer of the entity rather than two, but also so long as you have that one officer, you can do it without a corporate seal, and it's a reliable document. And the proposal is to make that requirement applicable not only to releases, which the statute has dealt with heretofore, but also transfers. Because one of the issues that we've come up with entitled, as in the news and everywhere else that you've seen, okay, do we have a valid transfer of the security instrument into who's trying to enforce it? And so we're trying to build a safe harbor around how we can get our arms around making sure that we have a good transfer of a security deed that can put the holder in a position to enforce it.
Mr. Chairman, just one comment. I understand that. Representative, if you wouldn't mind, I don't want to hold you up. Just would you get me a definition of corporation from the first part of that particular code section, just so I can have an eventual comfort level that that's not going to preclude those types of things. I've just seen too many times the laws of unintended consequences with these types of things.
You're referring to line 14?
Right. There will be a definition of corporation somewhere above that in the code section. I'm going to make sure it does not apply to limited liability corporations or others who don't necessarily have presidents, vice presidents, secretaries, but who yes. Do a great deal of the transferring of deeds to secure debt and mortgages and other security agreements.
Yes, sir. I will provide that to you. Sure will. You want now?
No.
Okay.
Sometime before rules. We've got a ways to go.
Yes, sir. So, I'll do that.
I understand you're right. Chairman Earhart, you're not asking that we amend the bill at this time. What you're asking is that he that's correct, and before we wind up on the rules calendar, sure that's addressed.
I think the very learned attorney from the Bar Association is probably right. I
want to make sure I understood you.
Yeah,
okay.
Thank you, sir.
All right.
Sure.
Ask for your favorable consideration.
Well, I think we got another question. Ms. Frazier, do you have a question?
I thought that the purpose of the corporate seals was to solidify that document, to ensure that document is authentic. So by removing the seal and just using a signature, what are we saying?
We're just saying that the corporate seal is not going to be required. And part of the issue out there is you have these security deeds, mortgages that are assigned many times, over and over and over again. And when I go and do a title search, I go in there and I see where there's a cancellation or release that's filed in the clerk's office, and I pick that document up, and it says cancellation. It's signed by a bank that I have the original document says it was with Northwest Georgia Bank, and this document says it's by Bank of America. And in between the filing of those two documents, there's not any assignment document. Okay, so first thing I'm going to have to do is I'm going to have to verify if that cancellation is proper, and I have to call. First thing I have to do is call Bank of America and say, okay, you got to show me some evidence where you were assigned this. And they send me a copy of that assignment, and they say, would you file this in the clerk's office? And I go up there and I file it and tell them they got to pay me the fee for filing that. What this does is this makes it where only when the president, vice president, secretary, assistant secretary signs it, then, and it's the legitimate, they actually hold that office, then that's conclusive proof that it's been released. I still have to go back and do those, find the assignment trail and figure out which bank went to where if I want to do a good job of making sure that's a proper release. So that it makes it easier for the banks to do the job properly. If it's a fraudulent document that's filed, then this won't apply to them because the president, vice president, secretary, assistant secretary hadn't actually signed it.
Well, we'll take whatever time you need. I mean, Representative Jordan, you want to try?
Will this bill make sure the right person or persons sign whatever the document?
Representative Jordan, you mind using?
Okay. Thank you. Will this bill make sure the right person signs the correct documents in order for a transfer to be possible legally? Because is this, and also, excuse me, does this also have something to do with what we've been hearing in the news about problems when individuals try to refinance their house or something like that?
Well, let me just give you an illustration, okay? I've been in closings where I've had another attorney over there, and they're representing the corporation. And they don't have the corporate seal with them. And they take that either the security deed or that cancellation, and they take a quarter, just like I did right here, and they draw a circle around that quarter. Let me see if I got my quarter here. I think I'm out of quarters. They draw that circle around that quarter. They just go around there like that. And on the inside, they write corporate seal, just like I've done right there. And that's the corporate seal. Now, is that the valid corporate seal? No. But it says the corporate seal. And the only way you can contest that is go back and find the corporate seal and say, this is what it is. What this does is this gives an exhaustive list of the people who can actually release it. And it says, don't give me somebody who's a signing officer. Don't give me somebody who's an attorney over at King and Spalding or, Weldon Law Firm that sign this. It's got to be one of these folks. And if they sign it and it's executed, you don't have to have that corporate seal. So, in my opinion, this improves the law because it makes sure it gives them a list, a bright line rule of the people who can actually release it. And once they do it, they've met the standard. Then we don't have all these convoluted. We have all these signing officers and people like that. I don't know what a signing officer is. I never had one in my office or any corporations I set up.
Representative Smith.
Representative?
Sir.
So to clarify, prior to the inception of House Bill 465, there needed to be a seal and a signatory from one of the officers, but what this does is take the seal requirement out and just has specifically the President, Vice President, Secretary, Assistant Secretary's signature to be the valid piece that we're looking at?
Yes, sir.
Okay.
And that matches the law for the, is it assignments or cancellations?
Well, right now the code doesn't require a seal. The existing code doesn't require a seal. These code sections are being clarified so you can't, so it looks to me, you can't just have anybody designated as the person deciding how you can set up releasing officer, transferring officer. That's what's confusing. And that's where you go looking for corporate seal. Now you don't need it. Under this statute, you don't need to ask them what makes them authorized. If they're not a vice president, secretary, or president, they've got to attach the corporate resolution and prove it.
Right.
This elevates the amount of work that the bank has to do over the current statute, but it makes it clear to them what they have to do. So you don't have some bank officer in San Francisco or New York saying, we're going to just pass a corporate resolution to make Susie Q the signing officer. And that's what they do right now. And this will tell you, it's going to have to be a president, vice president, or secretary, or assistant secretary. Or if you're going to do a resolution to make Susie Q your signing officer, they got to attach that resolution. That's the way
There you go.
We have another member question for Representative Weldon. No further questions. All right, Ms. Frazier.
Mr. Chairman, we don't have anybody here from corporations to speak from any corporation or to give their opinion on how this will affect them.
I think there's several people here that own corporations. I mean, me being one of them.
I'd just like to hear from them.
I mean, as from my perspective, I'm not going to give my perspective as chair. Were you going to say something, Mr. Dutton, the representative?
I was just going to say, I own a corporation, and anytime you go in there to handle this kind of matter, the banker's going to know who he's dealing with. And it's like you say, you don't have to tear your desk apart trying to find the seal, or you didn't have time to go by the office to get the seal. I don't think it's jeopardizing anything by removing this. Just making it a little, just cleaning it up a little bit.
Representative Hill. Chair. Chairman Burns.
Mr. Chairman, I'd like to be recognized for a motion.
I don't think there are any more questions, so now would be the appropriate time.
I'd move favorably on this bill with a due pass recommendation.
We have a motion and a second for due pass to the substitute to House Bill 465. Is there any further discussion? All those in favor will signify by saying aye. Aye. Any opposed, same sign. The motion carries. Congratulations, Mr. Wilson. And thank you all for being here. We're adjourned.